Hey guys, welcome to my channel. Today we're covering a courtroom hearing where an incarcerated father asks the judge to correct what he believes is a major mistake in his parenting plan and child support order. As the hearing unfolds, new legal questions emerge about visitation, no contact restrictions, and whether incarceration should affect financial obligations. The judge carefully weighs each request, leading to a decision that could significantly impact the case. Stay with us to see how it all plays out.
Rise. The Sumter County Chancery Court is now in session. The Honorable Judge David Wolf, present presiding. All who have business drawn near to be heard. God bless the state of the United States and this honorable court. You may be seated.
Well, my understanding is that Mr. Thornberry has filed this Rule 60 motion on February the 21st of 2025, seeking to correct an order that was entered on October the 22nd of 2024. His basis is that the parenting plan that was shown in that final decree or that order that was entered listed his income at $5,083.33 per month, when his income has been zero since April of 2024, since he's been incarcerated on pending charges, and that he's asking for the relief to amend the financial support section of the plan to acknowledge that he has no income. So, Mr. Thornberry, if I stated correctly what your statement is, what you're asking?
Can you say that one more time? I'm sorry, the audio here is not really good.
I understand. It's my understanding that you're asking to amend the parenting plan that was entered back in October of 2024 because of the fact that it incorrectly lists your income at $5,000 plus and that you have been incarcerated since April of 2024 on pending drug charges. Is that correct?
Yes, Your Honor. There was a few other points that I wanted to try to address while we were here today, but that was one of the main ones that I had sent in. I had sent in a few motions to the court that the clerk's office had received. One of the other things that I wanted to address, if I can speak freely.
Well, if you're going to testify about what you want changed, then I need you to raise your right hand. Let me place you on the road. Do you solemnly swear or affirm the testimony about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. What else are you asking for?
I was going to try to address the no contact order that the plaintiff has said has been in effect since we last went to court. I wrote a cease and desist letter that I actually sent to Mr. Hawley and to the clerk's office, asking them to, let me know about the no contact order that Christy said that she had. I wrote the clerk's office asking them to send me anything on file that they had saying that there was no contact order. Our parenting plan doesn't have a no contact provision in it or anything. I haven't been allowed to talk to my daughter for the duration of my stay while I've been incarcerated. And the second point that I wanted to see about is letting my dad, who's here in the courtroom, and my stepmom utilize my parenting time so that I can adequately visit and communicate with my daughter, because I don't believe that at this time that the mother will be willing to accommodate those. That's all, Your Honor.
Mr. Hawley?
Judge, we did not know it was
You need to speak before the microphone for him to hear you.
I think, we didn't know that it was necessarily set for today. I don't know if it was set today to get a date to hear his motions or whatnot. Mrs. Thornberry is not here. I haven't reviewed the file, so I'm shooting for the cut. But I would say, number one, we would be opposed to him reducing his income. Obviously, it's what he should have been making. He's in jail right now, and of course, the rearage is still sitting there. I understand it's a zero income, but he's there on drug charges and domestic violence charges and things of that nature. Nonetheless, to have
according to his information, he was in jail at the time of the last hearing, and it does show that when an order went down to suspend his visitation, that he was actually appearing by Zoom from the Dixon County Jail on that occasion. So my belief is that clearly, if he was incarcerated, I understand your argument about the fact that he may have a willfully unemployed or underemployed that you may have that argument to make because he's incarcerated, but it's pointless to set a child support amount when he is unable to do it. Mr. Thornberry, I'm not asking you to go into the facts of the case, but according to my review of the file, it appears that you are charged with 2 counts of attempted first-degree murder and then some drug possession charges. Is that, without telling me what happened, is that the charge that you're facing?
There's 3 counts of attempted second degree, 1 count of Schedule 1 drug possession, 2 counts of domestic, and then 1 count of resisting arrest.
All right. Well, let me just deal with this first and foremost. In my opinion, the suspension of your visitation has been properly heard by the court. You were given an opportunity to be present, and there's no basis to set aside that order because of the fact that you are currently incarcerated facing very serious charges. The order states that the suspension of your visitation would occur until such time as you are released from incarceration. Now, what that means is that as long as you're in jail, then you're not going to be able to see your children. Now, whether or not grandparents have a right to visit under a statute, that would be determined. The grandparents would have to file a motion for a visitation under the grandparents visitation statute, and that has not been done in this particular case at this point. But I cannot simply substitute your parents for you as far as the visitation goes. So under the circumstances, it would seem to me that the best thing I can tell you is I am going to suspend any order that sets his visitation or his child support at the current time based upon the fact that he is incarcerated and was incarcerated. I will suspend any operation of any child support order until such time as there can be a further hearing. And then that will give you an opportunity to have your client. I'm not back here until October, so it would be October before that portion can be heard. When it, again, not going into the facts of the case, but you have a lawyer, I assume, that's representing you on the criminal charges.
Yes, Your Honor. I go back to court October 28th.
Roger Wayne.
Yes,
Roger.
yes, Your Honor.
All right. Then you need to contact Mr. Winnick and just, explain to him what's going on. But I don't want to have you testify about your criminal, where you'd be subject to a cross-examination. And so for that reason, I'm just going to put an order down that suspends the operation of the parenting plan as to the child support calculation based on the fact that you're incarcerated and have no income at the present time. Your motion to alter or amend or do away with these no contact order is respectfully denied based upon the fact that you're incarcerated and have, in my opinion, there's no basis upon which I can find that there's any change from the prior hearing. So you can renew that if you choose to by filing something and having it set in October. But if you want to have this child support issue heard in October, we can set it on a day in October. Give him a date, please.
We could do October 1st.
October 1st.
I'm fine on that day.
We're going to set it on October 1st for us to review both the visitation aspect as well as the child support issue. Okay?
Okay.
10:30?
At 9.
At 9? Okay.
I'm
9
sorry.
o'clock?
You said October 22nd, is that correct?
No, October the 1st.
Okay.
That's the date. All right. Thank you.
If I'm correct, Judge, you're suspending basically the collection part of the child support, which is fine. We weren't.
Calculation of child support under that parenting plan is suspended based on the fact that he was not employed at the time that the order went down and has no income. So as a result of that, since he's still incarcerated, I think it's pointless to have that calculation in place. So we're granting your motion regarding calculation of child support until a hearing on October the 1st. Mr. Thornberry?
So the child support that's in arrears right now, is that going back from whenever the new plan went in place or from this day? Just for transfer.
I have found that the child support calculation was an error based on the fact that you were incarcerated at the time, and therefore it should not, but we'll deal with that on October the 1st.
Okay. Thank you very much, Your Honor. I hope you have a blessed day.
Thank you.
Thank you, Judge.
Call the next case.
This hearing highlights how family court decisions are often shaped by legal procedure just as much as personal circumstances. At the center of the case was an incarcerated father who argued that a parenting plan entered months earlier incorrectly listed him as earning more than $5,000 per month, even though he had been in jail with no income since before the order was issued. After reviewing the record, the judge agreed that continuing to calculate child support based on income the father could not possibly earn while incarcerated was unreasonable. As a result, the court suspended the child support calculation until a future hearing, recognizing that the financial portion of the parenting plan needed to be reconsidered. However, the father's additional requests faced a different outcome. He asked the court to remove what he believed was a no-contact restriction and to allow his parents to exercise his visitation rights while he remained in custody. The judge declined both requests, explaining that the prior suspension of visitation had already been properly addressed by the court and that grandparents cannot automatically receive a parent's visitation rights without filing their own legal action under the applicable statute. Because the father remained incarcerated on multiple serious pending criminal charges, the court found no legal basis to alter those previous rulings at this time. Rather than making permanent decisions, the judge scheduled another hearing so the remaining issues could be revisited once more information became available. The case serves as an important reminder that family courts must balance parental rights, financial fairness, legal procedure, and the best interests of the child while ensuring that every decision follows the law. Even when one aspect of an order is corrected, other requests may still be denied if the legal standards have not been met. If you enjoyed this video, don't forget to like, comment, and subscribe. Thanks for watching, and I'll see you in the next video.